Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Thank you for joining us for Speak Up. I'm Representative Kevin Avard. I sit on the Redress of Grievance Committee at the Capitol. Today's show is about a Dr. Vandenberg, a man who was never adjudicated as an unfit parent, and yet for the last 2.5 to 3 years, he has not seen his daughter. Is it because of religious bigotry, or is he a despised litigant? You'd be the judge of this one. Thank you for joining us for Speak Up. I'm Kevin Avard, your host, and today I have another guest from petitioner number 11 from the Redress of Grievance Committee, Dr. Vandenberg. I want to welcome you to the show.
Thank you.
I really
Pleasure to be here.
I'm glad that you're here. Everybody has a unique story, and we recently had on Marie Miller. She's having difficulties with the courts, and we definitely want to hear your story. I heard it on Redress of Grievance, and I thought it was very compelling and very clear. So if you want to start from the beginning.
Sure, I'll just, if you have any questions or want to interject, please do.
I will.
Okay, good.
All right,
I'm glad to hear that. Well, my case is really a family law matter. I have a daughter, Emily, she's 15 actually a couple days ago. About 3 years ago, almost exactly 3 years ago, there was an ex parte hearing which was held. Again, because it was ex parte, I didn't know about it until after it had occurred. I always call those secret hearings. It was an ex parte hearing, and the court took away all contact between me and my daughter, and it lasted for 2.5 years, the suspension of contact.
There seems to be a common theme, so I'm going to ask this question, and I do this with a lot of my guests. Are you a criminal?
Oh, no, I'm not a criminal.
Are you violent, or have you committed any violent crimes?
I'm a fit parent. I've never been accused of being unfit. I've never been accused of any criminal activity.
You've never been adjudicated as an unfit parent at any point?
No.
At any point?
There's never been any adjudication around that at all.
And for our listeners, could you explain what is an ex parte? For people who have not gone through the process, ex parte, that sounds legal.
It is legal. It just means that an ex parte hearing is a hearing in which one party is not notified that the hearing is occurring. So you find out about it after the fact.
Oh, and that's justice?
Well, to us it's not,
right.
But this is common practice in family court.
Okay.
I mean, in fact, I was at the family court, Cheshire Superior Court, in January. The judge asked me to hang around, and I did for 3 days, not on the court, but he'd come back in 3 days and get a ruling from him. I was waiting half an hour before it closed on a Friday. I saw 6 people come into the court with ex parte orders at the half hour before they closed. And these were women seeking to keep their kids away from the fathers for that weekend. So they're handed out like candy in the courts. I was just there yesterday. I saw another woman with another ex parte order with her daughter in the court.
All right, so you haven't seen your daughter for 2.5 years.
Didn't see her for 2.5, had no contact with her for 2.5 years.
No supervised visits?
Nothing whatsoever, which is an extreme remedy. People who have been found to be murderers, found to have been convicted of violent crimes, they have contact with their kids. They have supervised visitation centers. If they're ever let out of prison, they can phone the children. They can have email contact. But I had an injunction against me that was severer than that which is given to child molesters. And again, there was no allegation of that. The reason that was provided was I was taking my daughter to church, Methodist church, praying with her and reading the Bible with her. The most severe allegation against me was that there was a person on the phone in supposedly Africa who had prayed with my daughter on the phone and said he was going to cut a demon out of her. That was the allegation. Supposedly I was there for that. I was with my daughter the entire time that the allegation that this supposedly happened. That never happened. So here we have a false allegation, which is preposterous, that someone from 5,000 miles away is going to take a 5,000-mile knife and cut something out of my daughter. When you look at it also, I didn't do that. I'm not the one who's threatening my daughter, even if that did occur. I was the one who supposedly was there. So I was not allowed to have any contact with my daughter because someone else said she might be threatened, if that even occurred. I mean, the layers of impossibility go higher and higher and higher. And on top of that, the order was totally illegal because with an order like that, you have to have a finding of harm. There was no finding of harm.
So where did it start? When did they separate you from your daughter? And why? And was it on a temporary basis, and then it would just?
Well, an ex parte order is by definition going to be temporary, but it lasted for 2.5 years. How, in any stretch of the imagination, can that be a temporary order? I'm not going to give all the statutes and the case law about it, but even if it were an injunction, injunctions expire under New Hampshire law after 1 year. This lasted 2.5 years. You're supposed to have a hearing after 60 days.
Even after 60 days, I think I would be pulling out my hair.
I was pulling out my hair at the hearing because it was just so, at the hearing following the ex parte order.
Did the court order guardian ad litems, or did they order psychology tests or any type of professional findings?
Well, we had what they call a full systems evaluation, a custody evaluation.
Okay.
So that was delayed and delayed and delayed. So, but regardless of that, we finally did have, well, actually, to go back, in order to have a proper ex parte order, you have to have the findings of fact. And we had an expert at the hearing, Dr. Benjamin Garber, who said that if you cut off contact between the father and the daughter who have a close relationship, it can only harm the daughter.
Right.
So against the expert witness's testimony, that was done.
Isn't there a law on the books, I think it's 461A11, something to do with equal parenting, or?
Well, that's part of it. 461A11 also says that if you want to modify a permanent parenting plan, which governs parenting between divorced parents, you have to go through certain hoops. There are certain requirements you have to do. None of those were met in my case whatsoever. So every law that exists was ignored by the court. And of course, it was clear that had happened. So I went back trying to get the hearing, and I filed motion after motion for a hearing, which was denied. What we finally did is we filed a petition for original jurisdiction at the Supreme Court, and that was very helpful. It was denied without prejudice, which means we're not going to look at it at this point, but it said that I should file a motion to vacate the original order with the lower court, file a motion to remove the guardian ad litem in my case, because the guardian ad litem was the person who asked for the contact, not my ex-wife. It was the guardian who did that.
All right, I'm going to start. Is the guardian ad litem an attorney by any chance?
The guardian ad litem who was on my case had been an attorney, but she let her license lapse. All right,
and isn't it by statute that a guardian ad litem should be paid $1,000 per case?
That's correct. I don't believe it's by statute, but it's by court rule. Superior Court Rule 17.
Okay.
They have to be paid. The maximum fee amount is $1,000. If you want to increase the fee amount, you have to go back to the court and ask for that, and you have to have a substantive reason for that.
And what would be an example of a substantive? I'm on TV, right?
Right, exactly.
What would be a good reason?
I don't really know, but
And so that begs the question: what reason did they give?
Well, there was never any reason. The fees in my case went up to, I believe, about $40,000. And again, the cap is $1,000. They're supposed to go back to the court to ask for any increase, but I believe, again, about $40,000.
Is there a point in your case where, now, both parties are supposed to pay for this guardian ad litem?
That's correct.
Did you anger the judge at any point?
Well, I think I angered well, to be truthful, I angered the judge the very first time that we went into court. Because when we walked into there, the judge, Judge Arnold, started yelling at me. He said, the guardian made the allegations that she made, and the Judge Arnold started yelling at me, saying, "You must have done this, you must have done this."
Without any evidence?
I didn't get to say anything.
So we're looking at hearsay, basically.
Well, it's testimony from the guardian ad litem, based upon I don't know what.
What did she say that you did that the judge yelled?
Well, this goes back to 2005, so that was the original reason why we were in court, and there were allegations against me of abuse of my daughter. So we all went through that whole process. We had a whole...
You had to prove yourself innocent.
That's right. That's how it works in family court. The way it works in family court is, it would be good if you could prove yourself innocent, but we have a standard in this country, as I understand it, that you're innocent until proven guilty.
Right.
It would be actually better in family court if you could prove yourself innocent. But even when you prove yourself innocent, you are still deemed to be guilty in the eyes of the family court. So even though you can prove yourself to any allegations to be true or to be false, you still are bearing under the prejudice of the court because of the...
In the interest of the child.
In the interest of the child. And again, this is one of these mysteries of the court. Why does this happen? Right. There's many cases of this. Thomas Ball is the most famous one. I don't really know what happened in that case. He burned himself alive on Cheshire Superior Court because he was found, according to the court, to be innocent of abusing his child, yet he never saw his children in any substantive way after that.
Who was the guardian ad litem in that case?
I don't know. I don't know.
I think maybe the same one in Nick Haas's, or there was another case that we brought up. And the reason I asked if you angered the court, generally both parties pay the guardian ad litem.
Well,
did you end up paying the full freight on that?
In that case, yes, because what happened is I realized that my guardian had never been appointed by the court. In order to act as guardian, you have to be appointed. You have to have a court appointment. And again, that's Superior Court Administrative Order number 17. So you have to have a hearing with both the parties present and the guardian ad litem present. Never occurred. We never had a hearing. We never had notice of a hearing.
And did you ever have to sign a contract with this person?
Again, there's supposed to be stipulations, which is the contract, which lays out what the guardian ad litem is supposed to do and not do, and set the fees. There was never any stipulations. So she just basically walks into the court. We have her working on the case. I brought this to the attention of the court, Judge Arnold, that there was no appointment, no proper appointment, and that she should have nothing to do with the case whatsoever. And what happened with that is the judge became angry at me and ordered me to pay all of her fees. So before it was 50-50 divided, but then because I brought to the attention of the court that she had no proper appointment, she was charging amounts which were not ordered by the court against Superior Court Rule 17. Because of all that, he ordered that I pay all her fees. And he said, immediately you must pay, I think it was about $3,700. If I didn't get that to her within 4 or 5 days, I would be incarcerated. So I was threatened with incarceration for payment of fees for someone who was never appointed, never had a contract, and had charged fees which she was never authorized to fee.
All in the interest of the child?
I think it's in the interest of the court. I mean, this is the overarching theory that we have. It's in the best interest of the child. I don't see where there's any interest in the child to incarcerate parents who are not found to be unfit, who are perfectly good parents, and toss them into jail.
I think I asked earlier, I'm not sure if I just a clarification, did you ever sign a contract with the guardian ad litem at any point?
There was a original contract when the case started in 2005.
Okay.
And the way that it works is we had, she was appointed, she did her work, we had a trial, she's out. That's the end of it. And,
Okay.
and that's according to, again, to state law.
Clean
She's done.
slate, now you start all over again. In case the court needs a new
That's right.
guardian ad litem, you get a new one appointed.
That's right. Now, if something happens in the future, you can come back in and say, oh, I was the previous guardian ad litem in this case. I can be appointed, or one of the parties can do that.
Were you privy to any of the documentation that she gathered, this guardian ad litem? Was it totally open to you?
Oh, no. Recently had a trial, end of January, I guess that must be 3 or 4 months ago. And I had requested her entire case file. Parents are allowed to have that. In fact, you're required to have that by a case called Ross versus Godwa. So parents are allowed to have guardian ad litem files and review them. The court ordered that, but she never produced it. So we had a trial in which I couldn't get that information. I got it a month or so after the trial happened, and I found all the documentation where she was collaborating with my ex-wife to manufacture false evidence against me. So I found that in the case file. And that's why she kept it away from me. So now I have that. I requested a new trial. The court said no, so now it's on appeal at the Supreme Court.
Can the Supreme Court deny, don't you have an automatic appeal to the Supreme Court?
You would think so, right? It's a
loaded question.
Yes, I understand that. You would think so. That's a standard feature of American jurisprudence. It makes one of the things that makes us a wonderful country. In spite of all this that's going on in my case, I still like the U.S. But we understand that we have the right of review. If I believe something went bad in my case, I have the right automatically to be able to send it up to the Supreme Court, and they will review that. However, the Supreme Court, in its rulemaking authority, created a rule. It's Rule 3.9. So it's an exception to that.
In 1980, this rule came out.
Yes, you're familiar with that.
And it violates what statute in the New Hampshire Constitution?
The due process, it's Article 14 of Part 1. Everyone has the right to bring proofs in it. You actually happen to have a copy with you, don't you?
Yes, and we're trying to do a service, so it's Part 1 of the Constitution?
Part 1, Article 14. And every citizen in that version of the Constitution, says every subject, has the right to bring all proofs and evidence before the court.
This one right here, legal remedies for fee and complete impromptu, is that the one you're talking about?
That's it, that's correct.
Every subject of this state is entitled to a certain remedy by having recourse to the laws for all injuries he may receive in his person, property, or character to obtain rights and justice freely without being obliged to purchase it, completely without any denial, promptly, without delay, comfortably to the laws. Wasn't there one that also talked about familiar status?
That is a statute, RSA, and I forget the exact nomenclature on that. But there is a non-discriminatory statute that courts may not, or no agency of the New Hampshire government may discriminate against any person in New Hampshire because of marital status or familial status. So if you're a divorced parent, that's a family status or a marital status. However, 3.9, Supreme Court Rule 3.9, denies an automatic appeal to divorced parents. So we have before us a situation, if you're a divorced parent or a never married parent, based on that information there, you have no right to automatic review of your case by the New Hampshire Supreme Court, which is contrary to that statute, and it's contrary to the rights of due process. You have a right of review if there's a problem. And again, the U.S. Constitution has that as well.
Right. But for some reason, the court in its rulemaking authority has changed that status.
That's right, and that's a matter of concern. We're getting a little bit away from my specific case, but this is something which concerns every single case that goes before that.
The reason I'm bringing that up is recently there was a CACR 26, which
right.
Basically repealed the court making rulemaking authorities.
Yes.
This was one of the issues that the Senate needs to consider. And of course, the courts want to compromise on this, but bottom line is they're making rules that have the effect of law, which counter your Constitution.
That's exactly right. And there's two problems with the constitutionality of that. One is the Article 14 that you're bringing up there. But the second aspect of that is the separation of powers. And this was foreseen in the Federalist Papers. If you read Hamilton's, Hamilton always foresaw that the judiciary was the weakest branch of government. And he said it was the weakest because it had the most restricted power. The only power that the judiciary should properly have is to decide matters. Is this right or is this wrong? It had, according to the Federalist Papers that Hamilton wrote, it should have no legislative authority, no power to make rules, and no power to execute any laws.
And that's the way it used to be prior to 1978 here in New Hampshire.
That's correct. And with that 73A rulemaking authority, the New Hampshire Supreme Court then basically accomplished a power grab which imbalanced the balance of powers between the legislature and the judiciary.
And the bottom line is it's hurting the kids.
Well, that's
it's
the thing.
hurting the parents. It's hurting
That's right.
the families.
That's right. Because you don't have, now that we have the judiciary with the authority to make rules which are the same as laws, they can actually do anything they want.
Right.
This happened in Nazi Germany. When the Nazis took control over the state, one of the first things they did is they abolished the separation of powers. They put it all, of course, in the executive branch, which was Hitler. But you can also create a dictatorship, which is very common, through judiciary means. That happened in England in history, if you read that. But that's one of the problems that we're looking at here. We have a democracy because we have a balance of powers. If you remove the balance of powers and you put more powers in one branch than the others, you are moving towards a dictatorship.
And the people of New Hampshire have to know this. They
Absolutely.
have to know this.
Well, and they have the absolute power. They have the absolute power through their representatives
Right.
in the House and the Senate.
And that's one of the cases that I brought up when we were arguing this on the floor. The fact that the legislature is the voice of the people, and people have got to remember that.
That's right.
You cannot go to a judge and say, Your Honor, that's a bad rule.
That's right.
You can't. You'll be in trouble.
That's exactly right.
Right.
And that's one of the things that happens right now. Under the procedures of the courts in New Hampshire, you really have no right to a hearing anymore. If, let's say I have a beef with you of some kind, you did some work for me and I'm upset about it, you won't talk to me, so I go to the court. Well, I go to the court, normally you put a petition or you put something into the court. In every other state in the union that I'm aware of, and I've done some research on this, and I've talked to various people, I have my petition against you. I go to the window at the courthouse. I say, I'd like to have this docketed. They say, great. They docket it. They say, you're going to have your hearing on July 1st. Great. Then what they do is they send you a summons that there's going to be a hearing and you can respond to what I put into the court.
Right.
But in New Hampshire, that's not the case. I can go in and put it in, and they don't docket it. They don't have to docket it. They don't have to ever docket anything that you put in. So you can file a petition against somebody, and it may never, ever be heard. And that's the problem.
So that brings up the cherry-picking list that I want to bring up.
Okay.
If things aren't docketed and they're not time-sensitive, basically the judge can go look at a case and cherry-pick each case instead of have to hear them.
That's correct.
Now, under the system also, and I'm going to keep interrupting you, there's this whole idea, there's this rumor that I keep hearing from people that have gone before redress and other circumstances, that if you get on this despised litigant list, that cherry picking doesn't get moved to the front, it gets moved to the back or wherever it suits the judge instead of the child.
Right.
Who's separated from one of the parents or grandparents in
Right.
some cases.
Some cases.
Or put into foster care.
Right.
It seems to be a delay of justice and injustice, if anything.
Right.
am I on the right track here?
No, you are. You know, the basis of due process, there's two basic parts of it. One is notice of having a hearing and the opportunity of having a hearing. So if it's never docketed, you don't have the opportunity for a hearing.
Right.
And so if for some reason I filed the petition against you in the court and the judge knows me from something before, he can just say, I don't like that Vandenberg guy. I'm just not going to have a hearing. We're just going to sit on it. And you can do that. Judges and clerks of the court in New Hampshire can do that, and it does happen on a regular basis.
Through attrition.
Pardon me?
They're beating you down through attrition, basically.
That's right. And that's what I did. They took my daughter away from me unlawfully. Not one aspect of the law was fulfilled in that order. Not a single one. And I brought that up to the court, and what do? We're just going to sit on it. We're not going to have a hearing. We're just going to hope he dies. We're going to hope he goes away. And that's what they do over and over and over again with many, many cases. So they just hope that they will beat you back over and over. And that is the problem. That's why many lawyers will not handle these cases. If they think that a client has become a despised litigant, they will drop you because they're associated with you. I had one attorney in Keene who's an excellent attorney. He's a wonderful guy. And he said, David, I would take your case in a heartbeat. They have totally denied your rights and your daughter's rights. But I cannot take it because I will be associated with you, and you have become a despised litigant in the eyes of the court being Judge John Arnold. And they blackball you. You become a black sheep, and you cannot get any justice whatsoever after that. So no attorney will, in their right mind, take your case.
So there's no RSA or law that can force their hands because
there's none now.
They can make their own rules.
That's exactly right. They can make their own rules. There has to be a law that is passed in the legislature that requires cases to be docketed and to be heard within a certain amount of time. Already in Superior Court, there's a speedy trial rule. Cases have to be heard within 6 months. Look at me. My case was in Superior Court. It took 2.5 years. They ignored that rule as well.
So where does this stand with you and your daughter now?
Well, we had the trial end of January, got an order from March 1st, and I've had contact with her, which means telephone contact. The court ordered supervised visitation for me, and I won't go into that whole thing, but that hasn't worked for a few reasons. So what we're trying to do is have my mother be there to supervise the visits.
Has your mother seen her?
My mother has had no contact. No one in my family really has any contact for 3 years now. My father died in December. My mother called about, I think the day after my father died, and talked with Emily, my daughter, and said, hey, we really like you to come to the funeral. And Emily said, I can't come. So she had not seen her grandfather, had no contact with him. Well, had very, very minimal contact. Email contact.
Did they commit a crime or something in the eyes of the court?
Well, it's funny you mention that because I had a hearing on July 27th of last year, almost about 10 months ago. They were trying to shake me down for about $17,000. Immediately when I walked into the courtroom, the guardian ad litem came over with another bill for $17,000, which I had no knowledge of. The judge said, you have to pay this right now or you'll be incarcerated. I said, I've never seen this bill. I don't know what it's for. I can't verify.
Is debtor's jail, basically? I mean, is this what this is? What is going on
I don't
here?
think it's as good as debtor's jail because debtor's jail, from what I understand, you actually had a court hearing. You actually had the ability to mount a defense. You actually had the ability to review the information. With me and many other people, you walk into the court, they say, with me, they said, Judge Arnold said, if you don't pay this now, immediately, I will have you incarcerated.
So they levy a fine without a hearing and...
Without anything. And then he said, well, either it was the guardian ad litem, Judy Hamilton, or the opposing counsel, Kathleen O'Donnell, said, well, wait, maybe we can get it out of his parents. So the judge turns to me, will your parents be able to give us that money? And I said, how I'm sorry, you know, I'm right. Speechless about this because now they have become litigants into this matter of which they've not been a party to. So now they are supposed to be legally responsible for a bill which didn't exist 5 minutes before.
And yet they've not seen their grandchild.
have not seen their grandchild.
Or had contact?
Not any meaningful contact. There was a few emails.
Wow.
I
So-
know, what's an email?
And your daughter, does she seem distressed over this? I mean, she's got to be distressed over
Well,
this.
it's very sad because before this, she was saying, Dad, I want you with me more and more. I want you to all my school events and sporting events and all these things. And what really precipitated, this is the court stuff, but what really precipitated all this was my daughter was with me for longer periods, and she said, Dad, I want to live with you. And I said, Emily, don't talk to your mother about this, please. Don't mention it. I'll talk to her, and I'll see what we can do. And I think, I'm not sure, because I wasn't there, she must have mentioned it to her mother when she was angry at her mother or something came up.
Oh.
And so her mother knew about that, and she thought, well, I gotta cut this off right now. And so all this chain of events began after. I can't say that happened, I don't know.
Right.
But that was one of the last conversations I had with my daughter.
So,
So
2.5
now,
years, you've not committed a crime. The courts don't seem to be following any type of guidelines. They seem to be making them up as they're going.
that's right,
Stop me when I'm wrong.
right.
As you walk into the courts, you're handed bills of $3,700 to $17,000. Otherwise, you'll be incarcerated. You have to have supervised visits. Still having not committed any crimes. Have you gone under any kind of psychological evaluation?
We had a evaluator that came in and did some psychological evaluations.
And how did you do with that?
Well, again, he didn't go very well in my favor. He said I was psychologically harmful to my daughter.
Way?
Well, I'm not really sure. We had him on the stand and doing this. The difficulty with his evaluation was that I would call it what you call a mercenary evaluation. He had done the work, but he refused to produce a report. Now with that, and you're required to have a report by statute under New Hampshire law. So I was trying to get the report from him. He said, I will not produce a report until I'm paid in full. I said, that makes sense, but I don't owe you anything. That's what my ex-wife owes you. And he said, it doesn't matter, because she owes me, I will not do the finished report. So I said, actually, he refused to contact me after that, so I had no contact with him. So here I had a person who had a report, refused to produce it, and because someone else owed him the money. But I looked at the contract. He said he would come to court if requested by the parties. I requested it. He refused to come to the court. He refused to come to deposition. So I sent him a letter saying, you have a contract with me. You promise to produce a report if requested. I have requested, and you have said you will not do it. So I will have to take you to a civil court and sue you for the money that I have paid you to date for failure to produce your product. And he said, when he came to the court, that once he received that from me, he knew that I was a bad father and that I should not see my daughter again. So he conditioned my psychological evaluation on the fact that my ex-wife would not pay him the money.
How much was it, if you don't mind me asking?
Well, that's the thing. Originally, it was $900. By the time we got through all that, it was an additional $9,000.
Oh, my gosh.
It's just amazing. When he first started, again, this is all a mercenary mechanism. When we first started, he promised that the evaluation would cost $4,000 to $5,000. When he finished, it was about $15,000. And that's without the report, which he had promised, or that he said he would produce.
Did medical insurance cover this?
No, they don't cover this at all.
They don't-
This is not medical. It's legal. They don't cover this. So yeah, he says that I harmed my daughter psychologically, and he admitted that the reason he put that was because I had sent him a letter saying that he was required to produce his report, and if he didn't, I would take him to court. So it's all mercenary. If you don't pay me, I'm going to come out against you. And that's how it is across the board. It's a mercenary system. It's a shakedown. The guardian ad litem shake you down, and these people who make these psychological evaluations will shake you down.
Have you? There must be an attorney on your side at some point.
Yes, I've had good attorneys, but I couldn't afford them anymore. I mean, the attorney I had in Keene is a great guy. I can't afford him. Another attorney from Troy, just outside Keene, Wonderful guy, wonderful person, great attorney. I can't ask him to work for nothing. I can't.
How much have you, if you don't mind me asking, how much did you pay in, have you paid in attorney's fees?
About $90,000.
Guardian ad litem, 40?
Well, they're about 40,000.
Court fines or anything?
No. And the evaluation fee is $15,000 with another 9 on top of that, so that's getting up to $24,000. I mean, and with no end in sight. You know, Article 14, which you just read a few minutes ago, says that the justice is supposed to be free. I can understand paying for attorneys, but I don't see how you're required to pay for a guardian ad litem. When in my case, she was never appointed, we never had any contract.
No DCYF in this?
No, no DCYF, and that's the thing. Supposedly I harmed my daughter. Well, why was DCYF, which is the agency which has the mandate for investigating harm to children, they were never contacted in my case. And that's what I said. If there was harm to my daughter, let's go to DCYF. Let's bring it to them and see what they say. But they knew there was that it never happened. There was nothing to base it on. So they, well, you know, we're going to get an unfounded decision from them.
So where do we go from here?
Well, right now I've appealed this to the Supreme Court because we had a trial in January. The guardian ad litem file I got after the trial. It's against the law, against case law in New Hampshire. I was supposed to get the mental health records of my ex-wife. That I'm entitled to those according to New Hampshire law, as I read that. That was denied me. We had this kind of deranged therapist who wanted money before he, you know, to determine how he was going to rule on anything. That is a problem. And there's another thing which I'm forgetting, but there was some evidence.
Did the court see his evidence?
He testified, yes. Again, he was not supposed to testify because he's supposed to do a written report. I brought that to the attention of court, and I said, there's statutes about this, competency of expert witness. So by New Hampshire statute, he was not a competent expert witness, but the court said, well, we're going to have him come in anyway. So that's another problem. But again, on top of that, what happened is the court recognized its error, said that the original order was unlawful and was disgraceful and shameful. That's a good step. But rather than actually have a fair trial and a proper trial for me, it was fixed. I couldn't get the guardian ad litem file. I couldn't get the records that were ordered by the court. I had this guy who admitted that he changed his report because of finances. And then on top of that, there was some written evidence that was introduced 3 weeks after the trial into the trial evidence. That's against RSA 459, which is statements out of court. So we had opposing counsel, Kathleen O'Donnell, give that to the clerk of court, James Peel at Cheshire Superior Court. He gave that to the judge, the marital master, Master Forrest, and it was signed on by Justice Kathleen McGuire. So we have 4 people who are involved of violating the law, RSA 459, to fix the trial. So, I mean, I feel like moving to the moon. I might get a fair trial on the moon, but I won't get one in Cheshire Superior Court.
Now, somebody brought up the fact that you're not a New Hampshire resident.
That's correct.
Do you have legal standing to bring a redress to the redress committee?
I do.
I thought that was actually comical that somebody brought that up, but could you talk a little bit about that?
Well, this is a comedy of errors, so we might as well add to the comedy.
Yes, absolutely. It was brought up, well, we're not really sure if the Vandenbergs can actually, Mr. Vandenberg can actually bring a redress to the committee because he doesn't live in New Hampshire. Does your daughter live in New Hampshire?
She most certainly does. So she is a subject of the state.
Right.
The case is in New Hampshire.
But you don't live here in New Hampshire, and that's part of the argument. I'm really having a difficult time with the Democratic Party because they just don't seem to want to hear the people's complaint. Right. And whether people are watching this show are Democrats or Republicans, I'm sorry, but not one Democrat has brought a redress to this committee. And it seems as though we continually go on and we hear cases after cases. You know, we're just looking at it right now on the surface. I mean, you brought all your evidence. You brought the documentation to the committee. It's being vetted. If half of this stuff is true, then come on, let's hear the guy. But to throw out these red herrings,
right?
That, well, because you don't live here in New Hampshire, you can't come before the committee.
Well, if there's no good argument, you have to provide a bad one. So that's what a red herring is. So
Well, okay.
so the red herring is, I'm not a New Hampshire resident. I plead guilty to not being a New Hampshire resident. I was in the past, and my ex-wife is, my daughter is, and that's enough right there. You don't have to go farther, because I am subject to the laws of New Hampshire because my daughter is. If I walk into New Hampshire court and the judge says, if you don't pay $17,000 right now, I will have you arrested, I'm under the jurisdiction of the New Hampshire courts.
Right.
There's just no way out of that. The second thing is under, I believe it's the 14th Amendment to the U.S. Constitution, if you're a citizen of the United States, you have to have equal protection under the law of the states. So you're entitled to this protection of the state's constitution and laws. So if someone from Massachusetts comes, I was talking to someone earlier today about this. If there's a state trooper on a highway 1 mile out of Massachusetts and he has his radar gun out there, he pulls over a bunch of people, they all come to court. 10 people are from Massachusetts and 10 people are from New Hampshire. And if they go in and they say, well, all you people from New Hampshire, thanks for showing up, have a great day, and enjoy yourselves. And they take the people from Massachusetts and say, that's going to be $200 a piece, or we're going to incarcerate you immediately. That type of thing is prohibited by the 14th Amendment to the U.S. Constitution. Those people from Massachusetts get the same deal that the people in New Hampshire have.
Right.
I get the same deal that I am so lucky that I get the same deal as all the other wonderful people and citizens of New Hampshire in the family courts. Okay. It's an open opportunity against anyone in the world.
Well, we want to thank you for coming to the Redress of Grievance Committee. And who gave you wind of this?
The Redress of Grievance, I was thinking about that. I don't know where I heard about that. I think I saw it in the newspaper or somewhere online. And when I saw that, I thought, I was at that point where the petition for original jurisdiction at the Supreme Court hadn't even come up yet. And I thought, what am I going to do? I can't get a hearing. They took my daughter away from me. I can't get a lawyer. I mean, they've got this so wrapped up 6 ways to nothing. There's nothing a person can do. If they decide they're going to just get you, they'll get you. And you have no recourse. And that's what I think the Redress of Grievance Committee does. It's what is a person to do? Where are you going to turn? Family law matter, other matters. I was listening to a case earlier about a man who had his entire life savings, all his assets stolen illegally by a court up towards Hanover. I forget which county that is. Amazing story. But what is a person to do if the government agencies, the Attorney General refuses to look at it, the local police refuse to look at it, the courts refuse? And don't get me wrong, there are excellent police officers in New Hampshire. In fact, the vast majority are. Yeah. There are excellent judges in New Hampshire. That's not the issue. The issue is that there are few. And I used to practice acupuncture. I have acupuncture training. I had a wonderful practice in Washington, D.C. The first rule of medicine is do no harm. But it seems like the court's first rule is let's see how much harm we can do and get away with. So it just makes your head roll when you look at all these. There's my case and there's other cases. I found it out online. There's more access. There's a great place to find it is a website called Stop Judicial Child Abuse. They have a lot of good information on there. Right. I've contributed to that because I've been asked to, and they vet cases there. There are some people who actually should have their children taken away. Right. So I'm not one of those, and many of the people who are coming up here aren't.
Well, I want to thank you for coming on the show. My gut is always wrenching every time I go through one of these. Is there anything else? Can anybody help you by getting in touch with you? How would they get in touch with you?
The best way is my email, which is davidvandenberg@hotmail.com. Just a simple email address. We're working. What's happened is when we first started this, I thought I was all alone. I went to the court and I saw the horrible things that were happening to me. I didn't know where to turn, and I didn't know that there was anything. Luckily, I know the Lord, and the Lord helps me, and that was the rock on which I stood, and it saved me, I believe. But I found out about the redress of grievance. I found out about the other people who were involved, And we've actually formed a group of maybe 20, 30 families. Most of these are family issues, people who've had their kids taken away for reading the Word of God, for praying, for just the most average activities that every parent does with their children. I've seen children taken away. So we've kind of gotten a group together. We help each other out. No one's a lawyer in this group, but we know a few things.
Right.
And we're trying to bring this out to the public, and we are.
Public awareness is the main key, and that's one of the reasons we have this show, is for people like yourself and other cases, to come out and talk. Get it out there. You're not alone. And
right.
If there are other people that are very in like situation, they need to come out and they need to speak up. Because even if half of what you said is true and the other half isn't true, my head's still spinning for you. And I have no reason to doubt you. You brought your documentation in, still being vetted, as far as the veracity of the statements. But at this point, I've not seen anything that is questionable.
Well, good.
Nothing. I want to thank our viewers. Is there any final thoughts that you want to put out with New Hampshire?
I'm actually very optimistic. When all this started 3 years ago, there was no redress of grievance committee. I didn't know anyone else. But now what's happening is we're getting a lot of good movement through that committee and just individual reps and senators. Right. For instance, there was a bailiff who came up to me recently at a court and said, "Can I come up and talk to you about these things? Because I've become very well known in certain, either well known or infamous, right, depending on who you talk to."
Of course.
And a bailiff came up to me and said, "Can we come up and I want to tell you about the things I've seen in court. It just makes me sick." He says it's family court, but it's other courts, and there seems to be a pattern of widespread corruption among certain judges and in certain courts, and it's coming to the light. It's coming out. People are raising their voices, and I have never been happier in my life because I see these. We had a call this morning from a man who was divorced 30 years ago. The court came against him. They said, "You owe $2,500, not to his ex-wife, not to the lawyers, but the court itself is trying to get $2,500. It's a shakedown. This is what's happening. Certain agencies, certain people in different areas are shaking down citizens to take everything they have, and it's just outrageous. And it's going to stop. And thank God for people. I mean, literally, thank God for people like you, other people who are representatives, other people who are police officers who are coming forward and saying, I'm just ashamed of what I've seen as an officer. We've had police officers come forward. Right.
They're coming out of the wood, and people from all walks of life are coming out of the woodworks. Well, I want to thank my guests for watching another episode of Speak Up. Thank you, Mr. Vandenberg, for coming on, Dr. Vandenberg, for coming on the show. If you want to help them out, if you know of any attorneys who want to help out pro se, or if you have any legal advice that you can help, please contact us. You can contact us here at speakupnh@gmail.com or
David Vandenberg at hotmail.com.
And if you'd like to be a sponsor of this show, please give us a contact, call us, or email us. We're looking for people to help this mission to continue, and every bit of support is well appreciated. Again, until next week, thank you.